Houston Maritime Attorney. Offshore injuries are both common and devastating. When your a loved one has been injured offshore, it is important for you to know what your rights are and what you are entitled to receive as compensation. When you work with Rich and Winstock, you can reset assured that you will be working with a maritime injury lawyer with over 30 years of experience. That automatically ensures that you will have a leg up in court, as almost nothing is more important than experience in a courtroom. Contact a Houston Maritime attorney as soon as possible for your claim. When an offshore injury has occurred, it is important to understand what types of compensation you may be entitled to. Offshore injuries are governed by a complex and complicated state and federal laws which govern the type of compensation you may receive. For this reason, an experienced maritime injury lawyer, such as those at Rage and Winstock, will help you tremendously with your case. For a free consultation, a brief history of maritime and admiralty law. Maritime law and admiralty law are two terms that can be used interchangeably. Importantly, maritime law, also called admiralty law, is what governs offshore accidents. Maritime workers have almost laws adhered to certain specific laws that govern their industry. Although much of general maritime law in the United States come from the Constitution, there are other sources for those regulations as well. Below we it's some list some of the most important laws, statutes and religions that are critical when it comes to maritime injury cases. The Jones Act, also called the Merchant Marine Act of 1920. The Jones Act extends the Federal Employers Liability Act to injured maritime workers. Basically, it allows injured workers in the maritime industry to file personal injury claims against their employer. In order to do this, they must have been injured during the course of their job duties. The curricle statute states the following: a seaman injured in the course of employment, or if the seaman dies from their injury, the personal representative of the seaman may elect to bring a civil action at law with the right of trial by jury against the employer. Laws of the United States regulating recovery for personal injury to or death of a railway employee apply to an action under the section. What is the maintenance and cure in maritime law? Two important factors in Jones law cases are maintenance and cure. Maintenance is the compensation that your employer must provide to you while you recover from an illness or injury. The intent behind maintenance is to provide compensation for a recovering worker's cost of living on land. However, many maritime employers try to keep these payments to a minimum of living on land. However, many maritime employers try to keep these payments to a minimum. Working with experienced maritime attorneys can potentially give you a better chances at a higher maintenance payment in your case. Cure is the medical care that your employer must provide to you after you suffer a work-related injury. It basically compensates for the treatments necessary for your recovery. While many employers don't want you to know this, offshore workers have the right to choose their own doctor under maintenance and cure.